Subcommittee 3 to order. We thank you for being here. The delegates are very busy. They've got busy schedules, so we're missing a few people, but they'll get here. Delegate Garrett has a subcommittee meeting to chair, so we'd like to entertain your proposal first, Delegate Garrett. So if you'd come forward.
Absolutely. Thank you, Mr. Chairman.
2487.
Thank you, Mr. Chairman. I appreciate your indulgence in committees as well. You all have before you House Bill 2487. If you all recall, last year Delegate Landis had an issue, a constituent in his area that questions were raised about his status as a motor vehicle dealer, and so we decided, the General Assembly decided to ask DMV and the Motor Vehicle Dealer Board, the various stakeholders to get together in the interim and figure it out, put it all together. This is a work product. To my knowledge, Mr. Chairman, members of the committee, there isn't any opposition to this. It basically does, it does 6 things. In lines 111 to 119, it clarifies which activities make a person a motor vehicle dealer. And again, this language has been worked out with all the various different stakeholders. In lines 120 to 122, it provides that selling 5 or more vehicles creates only a rebuttable presumption that a person is a motor vehicle dealer. Today in the Commonwealth, if you sell more than 5 or more vehicles, you are deemed to be a motor vehicle dealer. Think about auction houses that are clearing different estates. People don't really sort of see those as motor vehicle dealers, and this would just give some greater clarity to that. The third thing it does is restores the exemption for the Virginia Motor Vehicle Dealers laws for the sellers of ambulances and firefighting equipment in line 135. So often localities and others will purchase these firefighting equipment and ambulances and so forth, and it really doesn't raise the same sort of consumer protection concerns as sales to individuals that other motor vehicle dealers would. Typically, that standard they would be held to. Fourth thing it does in lines 162 to 163, it clarifies that manufacturers and distributors selling vehicles to motor vehicle dealers are not themselves dealers. This is very important to make sure that we still clarify the concept of manufacturers versus the distribution chain, the ultimate retailers of those products to our consumers. Fifth thing it does on line 106 is it specifies that a trailer is considered a motor vehicle for the purposes of Virginia's motor vehicle dealer laws. We had some conversations with wire trailers. I wanted to make sure that those like Lowe's and Home Depot and so forth aren't going to get conflicted because they're not truly automobile or motor vehicle dealers. And this doesn't sort of conflict them, but we have large trailer dealers, 53-foot trailers that in fact are treated as motor vehicle dealers in the Commonwealth. And lastly, it adds the term new trailer sort of scattered throughout this to address. So again, Mr. Chairman, that's basically what the bill does. It's a lot of cleanup language, it's some clarification language so that moving forward, the communities and will understand the folks that are selling more than 5 vehicles that purport to be motor vehicle dealers are in fact dealers. Doesn't sort of cast the net on those others. Happy to answer your questions, sir. Yes, sir.
Anyone in the audience speak either in favor or against this eloquent bill?
Mr. Chairman, Ann Gambardella with the Virginia Auto Dealers Association. We worked as part of the group through the summer and we support the legislation.
Thank you.
Mr. Chairman, members of the committee, Edward Mullen on behalf of General Motors, and me too, we're part of the stakeholder group and appreciate the bill. Appreciate you bringing it. Thank you.
Thank you.
Mr. Chairman, Fred Helm on behalf of the Alliance of Automobile Manufacturers. We also participated in the stakeholder group and support them.
Thank you. Anything? Mr. Chairman, Doug, we do have a technical amendment.
And I apologize for that. As you told me that, Billy's got to go. There too. Emily, you have some technical.
Mr. Chairman, Delegate Garrett, on line 121, after presumed, insert 2, and on line 121, after B, strike 2. What this does is right now it says presumed B2, it should be presumed to B.
That's a little technical nature, Mr. Chairman.
We have a motion to remove the amendment. Second. Have a second. All in favor of the amendment, signify by saying aye. Aye. All opposed, nay. Amendment moved. Amendment is now properly before us. Anyone to speak in opposition?
No, he's got
Okay, great. Got a motion to report?
Second.
And a second. All right, with an amendment. Okay, go on the board to vote, please. Everybody vote. Motion reports 6-0.
Thank you, Mr. Chairman. I appreciate it. Appreciate the chairman of the subcommittee.
Thank you for being here. All right.
Yeah.
I think Delegate Plum signed up next. Thank you, Delegate Plum. Thank you, Delegate Plum, for allowing Delegate Garrett to go before you. something about your bill, Delegate Plum?
Sure, Mr. Chairman, members of the committee. This would provide a license plate for the Virginia professional firefighters, and you might say, gee, I thought they had a plate. And the answer is they do. There are about 1,000 of those plates out. But what the firefighters now are asking us to do is to move it from a non-revenue to a revenue plate. And what would happen then is members re-up their plate with $25 revenue amount. The firefighters would be able to raise some funds for the various charitable activities they're involved in. I think you know that all of our firefighters are involved in a whole host of charitable operations and so on, and this would provide them a way to raise some money in order to accomplish the purpose. I bring it third request.
Thank you, Dr. Plum. Is there anyone in the audience to speak either in favor or against this motion?
Mr. Chairman, Aaron Rice, on behalf of the Virginia Professional Firefighters, we do support this legislation and thank the delegate for introducing it. I'm happy to answer any questions.
Are there any questions? Thank you for being here. Does any member have any questions of Dr. Plum at this time? We have a motion to report. I have a second. And a second. Everyone vote, please. Motion reports 6-0. Thank you, Delegate.
You're talking about those
Appreciate you
right
being
there.
here. We have Delegate Quinn here. Delegate, you're signed up next. House Bill 2220.
Thank you, Mr. Chairman. This bill would create a license plate for recipients of Armed Forces Expeditionary Medal. There is a substitute that includes a one-time $10 fee for that plate. And it would join 8 other medal plates that we have, plus various conflict plates.
Doctor, let me get the substitute before it's proper.
Yes, sir, Mr. Chairman.
Do I have a motion to accept this? So moved. Second. Motion, substitute properly before us. If you need any time.
Good.
We're good? Substitute. You good? All right, substitute's properly before us. Goes, good, Doctor. Go ahead, please.
Yes, sir, Mr. Chairman. So as I said, this creates the license plate for the recipients of the Armed Forces Expeditionary Medal. I'm happy to explain more about that if you would like, but it does join, or would join, 8 other medal plates that are out there, various other conflict plates, World War II, Desert Shield, Desert Storm, et cetera. The substitute now has a one-time $10 fee, and that's pretty much the license plate in a nutshell. I have a gentleman who actually received that medal who had asked why we didn't have that, and he had at one point attempted to get enough people to prepay, but obviously couldn't track everyone down. It was very difficult to just kind of run a Facebook campaign to get 450 Virginians to sign up for this. So, spoke with Commissioner Holcomb, and this is the bill that came up with.
Okay, thank you. Is there anyone in the audience to speak either in favor or against this bill? Commissioner, you have anything to add?
No, sir, the patron outlined, and we appreciate his acceptance of our suggested amendment.
Commissioner, can I ask you a question?
Yes, sir.
Delegate Lethwich had a similar bill which allowed other members of the family to purchase a similar plate or an identical plate, but it was a $50 additional cost.
Yeah.
Was that considered on this piece of legislation?
Mr. Chairman, Mr. Chairman, in fact, what I reminded, or what I brought to the chairman's attention, Chairman Yancey, and Delegate Hugo may remember, when Leo Wardner was chair of the committee, he looked at all of these plates and he ranked them based on the medals and how the military branches rank them in order. The Delegate Lethwich plate was ranked, that medal was ranked number 7.
Okay.
This is more like 33 to 34 to 35. So the chairman is gonna ask us to study and look at what Chairman Wardner proposed and implemented that time, but this is more in line with where this medal is ranked.
Reasonable justification.
Yes, sir.
Thank you.
Yes, sir.
Any questions of the members of Delegate Quinn? I have a motion to report. I have a second? Second. With the substitute. Reporting with the substitute. All in favor, say, well, let's vote on the machine. We used to say that not any long. Report 7-0, Delegate. Thank you for being here.
Thank you, Mr. Chairman.
Okay. Next, we have Delegate Ferris.
y'all doing today? I appreciate you having me here.
Well, it's my choice, it's the fact that you submitted the bill.
I understand, Mr. Chairman. All my little bill does is it makes it more discretionary, for to issue tow driving truck registration to persons who are convicted of violent crimes or crimes involving driving, and including drugs and alcohol offenses, if these convictions were over 10 years ago. My legislation leaves out sex offenders. Says that we still prohibits sex offenders. And Mr. Chairman, the sex offender registry has been in place for 15 years. And so if you added 10 years to that, somebody has been out of prison and been on good behavior for 25 years. Or otherwise has done a nonviolent crime. It still leaves it at the discretion of the Department of Criminal Justice. It just gives them a little more leeway. I've got someone here to speak in favor of the legislation, and I hope no one's here to speak against it, but I feel like it could be.
Thank you, Kelly. Thank you. Is there anyone here to speak either in favor or against the legislation?
Mr.
Yes,
Chairman,
sir.
Eric Fly, the Hampton Roads Towing Alliance. I can't quite get out.
You're fine.
Okay, we support the bill. One of the issues that we're facing in the towing industry is there's 600 open slots in the towing industry for tow drivers across the Commonwealth of Virginia. An average salary of $42,000 a year, so we have a $26 million impact base that we'd like to fill. And we have a lot of people that would like to come into the industry, but because they have made a mistake 20 years ago, they're ineligible. When the Board of Towing Recovery Operators went away in 2013, legislation was put in and it basically stated if you committed a violent crime at any time, you could not become a tow truck operator. The delegates bill would then say if you hadn't committed that violent crime for 10 years and you've been clean, that you could get a tow license, and we hope that will pass.
Thank you. Anyone else to speak either in favor or against the legislation? Okay.
Mr. Chairman, if I could finish with another comment. I understand why this was put in place in, would you say 13 years ago? But Mr. Chairman, I think most cases now people have cell phones and they have the ability to call and get somebody to come get them. They don't wait necessarily for the tow truck driver and have to ride or be personally involved with the tow truck driver, as the case was 13 years ago. I think we're in a different time.
Thank you, delegate. Any members of the committee have any questions of the delegate? Would the report? I have a motion to report. Do I have a second?
Second.
I have a second. All right. We'll vote. If this is, I'll let you know that if this bill reports, it is to go to courts. Okay. Report and refer. Thank you.
Good luck, Bill.
Okay, the bill reports 5-1.
Thank you.
Thank you.
Might win, not win the war, but we win the battle.
Apparently hadn't been to court before, has All right, we have Delegate Thomas.
Thank you, Mr. Chairman. I have House Bill
Wait
20.
1 second, Delegate. I'm not skipping anyone
No worries.
that's not on the committee. There's no one else here to present any bills other than what we have here. Is that correct? I'll go ahead. Delegate, I just want to hold anyone up when you get out. Go ahead.
Thank you, Mr.
Delegate
Chairman.
Thomas.
House Bill 2551 looks to build on the foundation that Virginia is the most veteran-friendly state in the nation. And we want to keep it that way. So what this bill does is it requires the Commissioner of the Department of Motor Vehicles to waive certain knowledge and skills tests for people who are either current or former military service. I will state that service has to be within the last year, so it can't be that you drove a truck in the military 20 years ago, and all of a sudden you don't have to test. And we also, you'll notice in the bill text, we are referring to the combined federal CFR 383, which there's a bunch of things you have to qualify for in order to get this exemption of That's the intent of the bill.
All right, thank you, Delegate. Is there anyone in the audience to speak either in favor or against this piece of legislation? Commissioner?
Mr. Chairman, we thank the delegate for carrying this. He is so supportive of veterans. A number of years ago, FMCSA allowed us to waive the skills test for someone who is in that same situation, who military has been driving successfully. This allows us to waive the knowledge test as well. Good bill. In fact, you'll see it in a broader pattern, because we've got a agency bill that's coming over from the Senate that includes this. We are very supportive of what the delegate's trying to do.
Thank you, Mr. Commissioner.
Mr. Chairman, Dale Bennett, Virginia Trucking Association, we strongly support the bill. This will ease the transition of good quality folks that are coming out of military after serving their country, and we find them to be ideal candidates to come to work in our industry, and think it will help us address the issues we face with driver shortage.
Thank you. Anyone else to speak? I think this is a good piece of legislation, Rob, and I thank you for bringing it forth. I have a motion to report.
Second.
Have a second. We'll vote shortly. Bill, report 7-0. Thank you, Delegate. Delegate Bloss.
Thank you, Mr. Chairman. House Bill 1780 has caused quite a bit of consternation between parties. What you basically have is the insurance industry and the salvage industry competing for the same wreck, which is always, they're always going to be in competition. But having seen what happened on the Senate side, I would also like to follow their lead and write a letter to the DMV commissioner to do a study. To study a couple things. One, to see if there's any reason to have the chop shop, they call it an inspection, but it's not a state inspection, to see if that actually even nets any crime anymore. So I mean, the whole industry, I think, needs to be looked at. This statute's almost 30 years old. So I think we need to look at the whole salvage statute.
Okay. Mr. Holcomb, would you like to share in on this?
Mr. Chairman, the only thing to add is that on the Senate side, they want a very narrow charge to only look at the issue that's brought up in the bill. So that's how we're going to be charged from the Senate. If you want a broader look, there will be a little bit of conflict. But we're ready to do the study and report back to this committee and the Senate committee.
Delegate, what's your desire?
That's fine. I will. We will.
You can forward the letter.
Well, let me talk with Senator Cosgrove and let's make sure we've got it covered, because I think that the issue can't be solved unless you go a little bit deeper and solve some of the other issues in the industry. I think all parties would be amenable to that.
Well, that's fine. You have a letter drafted to satisfy your concerns with your piece of legislation.
Thank you, Mr. Chairman.
Yes, sir. Well, all right, so we have a motion to
PBI the bill.
PBI the bill.
Yes, sir.
Have a second? Have a second? All right.
What's the difference? Is it no different?
Okay, so that brings us to Delegate Harris.
Mr. Chairman.
I like the piece of legislation here.
A little bit more complicated than a license plate bill, Mr. Chairman.
Yes, sir, it is.
HB 2174, the purpose of which essentially is to provide some clarity and some clarification in the code. And I want to just be clear for the members here, there's a couple things we're dealing with. I want to tackle the first one, which is the right to first refusal. And without getting too much in the legalese, but kind of tell you a little bit what the courts have been doing and kind of what it actually means, because there's been some confusion of what it means when I found out after talking to people.
Delegate, if you wouldn't mind, let me get the amendment.
Oh, I'm sorry. Let's
Substitute
get,
before
there's
first.
an amendment nature of a substitute. We can go ahead and have the committee accept that. That'd be great.
Thank you.
Move to adopt.
Let me have Emmett tell us a little bit about what it does, just if you don't mind, Delegate. Emmett, Emma, you mind sharing a little bit of what this amendment does?
Not at all. We did.
And I think both parties have a copy of this amendment. Okay.
refusal, a distributor or manufacturer can still exercise that right if the manufacturer or distributor has a formal written program to increase minority dealers, and exercising the right of first refusal would give a minority dealer at least a 51% ownership and control of the dealership's assets. So that is a change from the introduced bill. Additionally, the introduced bill provides that if the contract between the distributor and the manufacturer is discontinued, then the dealer, let me just make sure I'm stating this correctly, that the dealer what the new bill does is that it provides that that the discontinuation or the sale or the transfer would constitute a termination of the franchise, and elsewhere in the code we deal with the remedies involved when there's a termination of the franchise. The original bill just said that such a discontinuation would not trickle down to the franchisees, it would transfer between manufacturers and the franchise.
Thank you. So I have a motion to accept the amendment of nature of substitute. Have a motion, have a motion and a second. All right, the amendment is properly before us. All in favor, signify by saying aye. Aye. Motion is properly.
All right.
Go ahead.
Thank you. So the legislation kind of has two tracks, and I have some people that can testify, including some dealers, deal with the discontinuation issue. I'm gonna first tackle the right to first refusal issue. Traditionally, it was always occurred, the right to first refusal in case of a manufacturer. So the manufacturer gathers with a dealer, and they simply say, if you sell that dealership to a third party, we have a right to first refusal, which traditionally has been interpreted to mean that manufacturer, let's say it's Ford, has the right to step in the shoes of that third party buyer. But traditionally, it's always been the case that we have the right to step in the shoes of that third party buyer, but we have to make the same offer, the same deal at the same price. That's traditionally what right to first refusal has always meant, both in manufacturing and in land deals, things of that nature. It does not give you carte blanche freedom to essentially veto power, using a right of first refusal to veto power and stepping in the shoes of a third party to squash the deal. What we've had recently in Virginia are some court rulings, not just Virginia, actually nationally, that has muddied the waters. There's a federal ruling on March 31st of 2017, which cited this section of the statute. It said 46.2-1569.1, while the statute creates a right of first refusal and establishes the general procedures and conditions for it, it is silent on the scope of that right. Well, you can see what happens when us in the legislature, when there are court rulings and there's some confusion, it creates a little bit of chaos. I want to be clear here, and there's going to be some testimony, I'm sure, from the big manufacturers going to the dealers of saying, well, this really kind of hurts our ability. I want to be clear through all of this discussion. The right of first refusal and what we're seeking to do here does not take away the bundle of rights that manufacturers have going into today and will go in today if the General Assembly changed this. I want to be absolutely abundantly clear. Because the way the code reads is, yes, if you're going to exercise the right of first refusal, you have to step in the shoes of that prospective buyer at the specific terms and price of that buyer. You can't decide suddenly you want to slice the salami and say, well, I'm going to exercise the right of first refusal on just this area. That's traditionally not how right of first refusal has been recognized in Virginia. If you have a ready, willing, and able buyer, just basic economic freedom, we're going to essentially say you should be able to exercise that right. We're not going to allow you to use the right of first refusal to stop that. However, the manufacturers have an enormous amount of rights and freedoms to still stop the sale. I want to be absolutely clear here. If the manufacturer is sitting there and decides they want to stop the sale, they absolutely can. Under the 46.2/1569, a manufacturer essentially can stop because of lack of good character, lack of reasonable motor vehicle dealership management experience, lack of financial ability of the dealer, fails to meet the standards otherwise established by this title to be a dealer. There's a host of rights both at the front end and once you are a dealer at the back end. If they're non-performing, if they don't meet the standards set forth, that the manufacturer could come in and essentially put the brakes either on the deal before it happens or after they have already operating, decide they're not meeting the standards they have set forth. So what this does in the right to first refusal aspect is provide, I think, some much needed clarity of what's happened with the courts. It essentially says manufacturers have to truly step in the shoes of that third party buyer, which is traditionally the way we've always recognized right of first refusals. And I know there's some dealers here, and perhaps some people from the auto dealers. I know there's been some new language on the discontinuance aspect that I think would be helpful, but the discontinuance part of the bill essentially is saying if you're a national manufacturer and you discontinue a line, you have a dealer here, and you're the national or international manufacturer Toyota, and you discontinue the third party, ship your cars first to say Toyota North America, you discontinue that line, Toyota North America Incorporated, and you discontinue that line, it simply says the dealer isn't going to be hampered by that. That they're going to be able, if there's a discontinuance, they could essentially still be able to sell, that new party will step in the shoes of who they've discontinued with, so it gives a little bit more protection for the dealer. So I know there's going to be people that speak for and against it. Look forward to answering any questions. I don't know if you want to go ahead and turn this over to perhaps some people from the auto dealers who could speak specifically on perhaps some clarification of this language. Thank you, Mr. Chairman.
We'll do that. Thank you, Dolly, for presenting your bill. Who would like to speak in favor of the bill? Who, in favor of the bill first?
Mr. Chairman, I will not take much of your time. I have a couple, I'm Don Hall with the Virginia Auto Dealers Association. I've got a couple car dealers who'd like to give up a very brief testimony from their perspective, who they are and what they are. And then I'll have Ms. Gambardella, our staff attorney, talk about some of the nuances just to give you some more understanding. I would say to you that this committee in my 30+ years has dealt with these kinds of issues over the years. They are complex, we understand that. It's not something as car buyers we know anything about. And so we'll do our very best to make sure that we enlighten you properly and that you understand the nuances of this. We have worked with the manufacturers. We try to work things out. Unfortunately, we're unable to do so at this time. And so we ask the committee to give this bill great consideration and allow our witnesses. I'll first ask Ms. Liza Borges to come forward, who is one of our dealers. She'll tell you who she is and where she's from.
Thank you all for giving me a moment. I'm Liza Borges, and I'm the president of Carter Myers Automotive. We are a family and employee-owned dealership group here in Virginia. We have 16 franchises across the state, 13 different locations, and about 600 employees. I'm the fourth generation of my family to run this business, and we've been around for about 94 years, starting in Petersburg, Virginia, so not far from here. This bill directly impacts my business, and it impacts the future of our business. My job is to take care of our customers and to take care of our associates and their families. It always looks on paper as if we can negotiate with our manufacturers a lot of the contracts they put in front of us. The reality is their depth of legal assistance and team is a lot larger than mine. And so when we're given a contract, really in order to stay in business, whether it's a sales and service agreement or franchise agreement, we're simply required to sign it. And I have to rely on our legislators to protect us. Oftentimes I sign it knowing that the Virginia franchise law is going to protect me and say, okay, I can go ahead and sign this knowing that I'm going to be able to stay in business regardless of what the pieces of this agreement say. So I would just really ask and encourage you all to support us as dealers so we can keep taking care of the consumers of the state of Virginia and hopefully be in business another 94 years. Thank you.
Mr. Chairman, I'd like Mr. Larry Page to come forward as well.
Good afternoon. My name is Larry Page. My father started at Falls Church, Virginia in 1950. We have Bill Page Honda, Bill Page Toyota, and Bill Page Chevrolet in Falls Church. Here in Richmond, we have Westbrook Honda, Westbrook Audi, Westbrook Volkswagen, Westbrook Kia, Mechanicsville Toyota, and Mechanicsville Honda. I just feel if the manufacturers can query a deal that I put together with and blow the deal up for myself or my wife or my children, I just don't feel this is right. I have never been involved in any negotiations of a dealer contract. It's pretty much what is written, what is put in front of you, and you sign it, or that's it. So I hope you support this bill.
Good. Thank you.
Mr. Mr. Chairman, Ann Gambardella with the Virginia Auto Dealers Association. Just wanted to make a couple of points about the bill. On the issue of the right of first refusal, Delegate Miyares laid out quite well why we're here. The courts have said your statute doesn't tell us what we need to do. And when you have these multi-franchise, multi-generation businesses, when the time comes for one of those businesses to be sold, the dealers should have the right to have the value of their businesses appreciated and not be able to carve them up as the court did in a recent case. The right of first refusal anticipates that you step into the shoes of the buyer, not that you start debating about which piece is worth what. The idea is that it's an easy process, and the substitute buyer, if you will, would just be able to step into the shoes and take on that deal. What we have put in front of you would prohibit the exercise of that right when the sale is to another franchise dealer. It's not an absolute prohibition on the right of first refusal. We recognize that a person has to be qualified. As Delegate Miyares mentioned, there's another section of the code that gives manufacturers the right to approve dealer candidates and or to reject them on certain grounds. This is really an issue of the manufacturers needing to put forth the grounds on why they're rejecting someone. So that will fix that part of the code section that has been sort of upended by the court decisions. And then as far as the discontinuance of a manufacturer, our original approach would have said that if a manufacturer sold a franchise, say Chrysler sells Jeep to General Motors, that General Motors would be required to take on all those existing Jeep dealers. We recognized the manufacturer's concern about imposing those franchise agreements on a new manufacturer. We took their comments into consideration, and we changed our approach to match something that they wanted us to do, which is to say those dealers that are not taken on by the new manufacturer, the selling manufacturer will have to compensate them under existing code sections that the General Assembly passed in the wake of the bankruptcies that we saw in the early 2000s that put a number of dealers out of business. So it just makes it clear that there is compensation for those dealers that are not picked up by the new manufacturer. That was something we agreed to in consultation and working with the manufacturer's representatives. So that's sort of the long and short of what the bill does, and we'd be glad to answer any technical questions.
Yes, I have a question.
Sure.
Do basically all of these contracts read the same from different manufacturers to the dealers?
The terms are not the same. What they do have in common, however, under Virginia law, they are required to include a provision in their contracts that says where this contract conflicts with the laws of Virginia or any state where it's to be executed, that the contract is conformed to comply with the laws. So there's a long-standing tradition of legislating this area, and the manufacturers fully recognize that their contracts are subject to the laws of Virginia. So insofar as the franchise laws go, all of their contracts would be similar on those instances because the law would require it. But otherwise, they're free to make their own provisions.
Now, if I understand correctly, the problem exists because franchises over the years have accumulated different product lines.
That is exactly right.
And now if they want to sell a product line, a particular manufacturer could come in and say, well, I only want to buy this product line.
Correct.
Just say they have five product lines.
Correct, if
So
there
they
are
could
5
come in,
franchises.
if they wanted to sell all 5, someone could come in and say, well, I only want to buy the one.
Yes.
So that's where y'all have concerns with this.
And the problem with that is, as you can imagine, make it simple if there's 2, and this was the case in the court case that we had. It was a heavy-duty truck dealer case. There was a Volvo franchise that was very valuable, and another franchise that was not as valuable on the same piece of dirt in the same facility. Volvo came in and said, no, we just want to separate out our Volvo franchise. Well, that's all well and good, except when you take the Volvo franchise and you take it out of the facility, now the other franchise and the facility have both become obsolete, if you will. The one remaining franchise couldn't even support the existing facility. So yes, you are correct. It truly has become an issue with these large multi-franchise groups. The manufacturers are perfectly happy to have Mr. Page and Ms. Borchis use their good names over generations to sell the products, and when it comes to the point that either one of them wanted to sell their business, the manufacturers at that point should not be allowed to undercut the value of those businesses.
So explain to me, if there are 5 different do then, Ann? I mean, how does that work?
That was exactly our problem, Mr. Chairman. We tried to write a bill that would put in place some procedure on who gets to exercise, how you give notice. We couldn't make it work. That's why we've come to you with a bill that says you just don't have the right to exercise it. If the buyer is a franchise dealer somewhere in the country, it eliminates the right of first refusal on those deals. We could not find a procedure that would put in place something that would be workable in a practical way. We couldn't find a way to evaluate the various pieces. It would spawn all sorts of disputes about who got notice first and what piece is valuable about what. We hear you, we tried to come up with that bill and we couldn't make it work.
Okay, thank you. Any other members of the committee have any questions? Thank you very kind.
Thank you.
Anyone else to speak in favor of this? Anyone to speak in opposition? Don't all run at once.
Mr. Chairman, members of the committee, Edward Mullen with General Motors, and I'll be very brief because I've got somebody from General Motors here to speak. I want to start by acknowledging Delegate Miyares and others have said, we certainly understand the issue that the bill is intended to get after, and I think everything you hear from us, I hope you'll hear in the context of, we just think the solution that's been proposed to date, even as amended, maybe has some unintended consequences that would be good to continue to work on. Before I bring Jeff up to give a manufacturer's perspective, I certainly want to acknowledge the work of the VADA over the past several weeks. We've worked very hard with them and in good faith, and I want to acknowledge that the changes that are represented in this substitute before you are not insignificant, and we appreciate that. I think Jeff will make a couple of points that we think, from our perspective, still need to be worked on. We've been working on them in good faith as recently as today, and we'll certainly continue to if the disposition of this committee is to move forward. So ask Jeff Perry from General Motors to come up and thank you, offer.
Welcome, Jeff.
Thank you very much. Members of the committee, as Mr. Mullen said, my name is Jeff Perry. I represent General Motors, the small manufacturer. So there's a reference to the large ones coming today. I do want to point out and thank VADA folks. We have made a lot of progress in a very short amount of time. I think we've had the bill maybe 6-7 days total between the two of us. So going back and forth with language, we've really worked out all but really this one last issue, I think, on the right of first refusal. So in this bill, House Bill 2174, the discontinuation language, I think we've reached agreement on that, and in the language that should work for both sides. On the right of first refusal piece of it, there were some questions earlier. Situations where there's 5 manufacturers involved or 4 or whatever it is at a particular dealership. A lot of this is because over the years the state franchise law has changed the dynamic between the relationship of manufacturers and dealers to the point that in the past, manufacturers did only have an agreement with that dealer, and that dealer had a standalone site for that manufacturer. And over the years, the state has changed the law and said it's okay for you to work with these other manufacturers in the same building. And at the same time that all that was happening, there were never any considerations or changes made to adapt the manufacturer side of that equation. And so manufacturers find themselves in these unusual circumstances where we still have a contractual right of first refusal that's been in place all along. There may be circumstances, and I'll go through a couple examples of some of the consequences that we're concerned about here, but there may be circumstances where we feel it's appropriate to exercise that right of first refusal. And when we do that, the manufacturer then can only really buy out its portion of the store. I, General Motors, cannot buy a Toyota store because what am I going to do with it? I can't be a Toyota dealer. Toyota's not going to let me sell their stores, so I'm left with dealerships and franchises that I can't do anything with because the law has never given any consideration to, well, what does the manufacturer do then after this all happens? So we've been working with VADA on that issue. We're trying to come to some sort of resolution and compromise on the language to figure out where this falls on that point. But the language as it stands in the amended version of the bill at this point is unfortunately not something that works for us for a couple reasons. Number one, the premise says that if a dealer owns or is licensed as a dealer with a franchise by any manufacturer anywhere in the United States, that they are therefore automatically get a pass when they do a buy-sell with another dealer, and the manufacturer cannot step in. And unfortunately, that doesn't necessarily meet the qualifications of every manufacturer. What Toyota holds its manufacturers accountable for under their agreements to be a dealer might be different than GM, might be different from Kia, might be different from Dodge. And in those circumstances, to say that a Dodge dealer in California wants to buy a store here in Virginia from another dealer, and so he automatically qualifies as our candidate, we can't do anything about it, forces us into a relationship that we may not want to have. And there may be any number of reasons that we might do that. A couple of examples that I'd like you to consider where we might be looking to exercise this is, number one, a situation where the market itself, so the local community where the dealership that's being sold, just is no longer going to support that dealership. There might be 3 or 4 other dealers that have the same line length in the surrounding community, and we find that the market for that consumers in that area has shrunk over time, and that it will no longer support the 4 total dealers in the marketplace. And so with this one selling dealer taking the opportunity, saying, I'm done here, I'm retiring, I'm getting out, and I want to sell my dealership, the manufacturer steps in and says, I will give you the negotiated value that you came up with your buyer. I'll step in the shoes of the buyer, make you whole, but I'm going to close that point down because I think that will actually make the remaining dealers stronger. And so using the right of first refusal as an opportunity for us to actually close down one of the points that might exist to make the community and the other dealers stronger for the benefit of the dealers and the consumers is, I think, one common reason that when this right is exercised that the manufacturers turn to this. Another one is kind of the opposite situation. It is used by manufacturers to prevent circumstances where a single dealer comes in and starts buying up all of the points to the point that they potentially control the marketplace. Where that dealer comes in, and now maybe it's a big box dealer from out of the state comes in and says, hey, I want to have the store that you're selling there, and by buying that, I'm going to be strong enough, I'm going to run either run all the other guys out of town and eventually buy up their stores, or I already own all 4 of the stores and I want to buy this last one in this community for 100 miles, and now everybody has to come to me for a car. I get to control the price on every brand, and there's nothing anybody can say about it. Those circumstances are not in the best interest of the consumers, they're not in the best interest of the manufacturers, and they're not actually in the best interest of the community or the other dealers that are your local dealers that have a single store in the family. And so that's an important one. I think the amended version of the bill has language in it to address the third situation where, so as it's drafted, if you take a step back and read what that language actually says, the state would actually be creating a favored dealer status. So anybody that already has a dealership, franchise dealership, you become the favored dealer, and anybody that's selling a dealership is only going to want to do a deal with you because you now have favored status, nobody can get in your way, can't be turned down. And anybody that wants to become a dealer that doesn't already have a store is going to have that much more difficult of a time getting into a store because nobody's going to want to do a deal with you.
Excuse me, Mr. Chair.
Yes, sir.
What recommendations have you offered for the bill to address your concerns?
So one of the recommendations that we've made to address the concerns that I'm raising right now would just be an exception to this language that says that if the manufacturer sees that the market just simply can't support all these dealers, that we would still be able to exercise the right of first refusal to the benefit of the remaining dealers. Another one is if there's going to be excessive market control, that the manufacturer could say no, step in order to prevent that excess market control. And for the purposes of this particular issue, we did offer language for minority dealer programs, so that a manufacturer that has a minority program for diversity candidates could say no to the original proposed buy-sell in order to offer that deal to a minority candidate in their program.
which is in I believe that's reflected in the
That's reflected in
substitute.
this amendment, that one issue is reflected in this, correct.
Delegate Hugo has a question.
Just to follow up on that, I mean, I understand it all sounds reasonable but who would determine excessive market control? Is that determination something to be made by the manufacturers? Or is there some criteria? Because if you can solely determine excessive market control, that basically leaves you in control of everything.
Well, if the manufacturer made the determination there was excess market control and the selling dealer wanted to protest that turn down for that reason, manufacturer would then bear the burden at hearing to show why we believe there's excess market control through detriments.
Just my ignorance, so if you have some sort of, is there a binding arbitration, or what is the board, you said the manufacturer would bear the burden?
I believe in Virginia, and correct me if I'm wrong here, I don't practice here, that the Motor Vehicle Commission has your hearing, the DMV? DMV. And then the same would hold true for where the market's no longer going to support all the dealers.
But the manufacturers, you could appeal to DMV, but the manufacturer is the original judge, the first judge that would hear this, is that correct?
Right, they would give the dealer that as their reasoning for saying, I don't think this is an appropriate candidate, and here's why.
Thank you, sir.
Thank you. Continue.
Thank you.
Yeah.
Good.
You know, that's the basis of my testimony. I mean, if there's any other questions.
Is there anyone else to speak in opposition?
Yes, sir, Mr. Chairman, Fred Helm, on behalf of the Alliance of Automobile Manufacturers, which is about 70% of the automakers in the United States, of which General Motors is one. You all one thing I wanted to say, I did want to thank the association. They did incorporate a few amendments and the concepts that we asked for, and we're appreciative of that on the minority dealer program. They incorporated that concept, as well as the failure to honor language on line 53. And we are negotiating, and we're very appreciative of those conversations. You all are hitting exactly on the crux of this issue. Line 34 is overbroad, and that's the problem. We need a little more time to work out the language. I mean, the valuation of a multi-line made dealership is complex, and our members have only a contract with one line mate, right? It's only one. So how do you, when there's a sale that is to occur, what this language says is it occurs no matter what, essentially. It's overbroad, so we're going to keep, if it's the will of the committee to move this right now, today, we're going to keep working with the association on how to value a multi-line mate deal, and that's what this is about. We're going to keep working with them. We would prefer and ask for more time, but if you do move it forward, we're going to keep working with the association. We have a good conversation going, and I hope that continues because we can get there. I think there's a solution here on how to do it right, how to negotiate and figure out you're hitting exactly on the point. What's the process if one manufacturer has an issue or there's one that's more valued than another? That was the point you made, Mr. Chairman. There's a solution here. We just need to get the words right on how to handle, what's the process to make sure there's a fair value for the business and the manufacturer's rights are protected too. So
Sure.
No, I was just, Mr. Chairman, I think you and I have talked to the full committee chairman. You're asking for more time. I think my understanding is going to be come up next week, correct? If you were to pass, it may come up to the full committee, which will give you.
Full's Thursday. We meet again on Thursday, but we may pass it by and bring it like on Tuesday. Now, you all understand, short session, time is of essence, and if we need to refer it somewhere, we need to do it very quickly. We don't think we do. We think it falls under the statute that it's in right now. That's where the bill should be heard in transportation.
Right.
But we may move it out of here today, but we would hope that you all would continue to work to refine the bill.
You have our commitment on that, Mr. Chairman, and the communication's been great. We're talking as late as today, so we're very appreciative of the efforts already that have been made, and I hope we can keep working on it because there's a solution in there.
Well, we thank you for that. We think it's in the best interest of all parties. Michelle?
Mr. Chair, members of the committee, Michelle Sutherland on behalf of Volkswagen Group of America. Volkswagen is the only manufacturer headquartered here in Virginia. We are located in Herndon. With our Electrify America subsidiary, we have approximately 1,000 employees here. And I want to echo what's already been said in terms of thank yous. I appreciate EADA's efforts to work with us. I especially appreciate Mr. Page being here. He sells our vehicles, Westbroad Honda, or Volkswagen, and Audi. But as has been stated, this is a very complex issue. We've had right of first refusal in our contract since 1997. This bill seeks to upend all of that. It seeks to interject government decision into a private contract between two very sophisticated business entities. We do need more time. I think we understand the concerns, but it hasn't been 5-6 days. We just need more time to get this right. So I would ask that you consider giving us more time. That's important. And if we can't get there, right of first refusal, as has already been discussed, gives us that protection we need to protect our brand. So it's important that it stays, but we're happy to look at other language that protects and makes it a little more narrow. So that's where we're at today. I think I've met with most of all of you. We're very concerned about this. We wanna address the problems and ask for more time.
Thank you, Helen.
Thank you.
Anyone else? Okay, any questions? Doug, your bill.
Your Honor, I just called you Your Honor. That is a bad habit of somebody who's like, Mr. Chairman, not an insult to you that way. Mr. Chairman, I would just like to point out a couple things. I appreciate all the testimony. I understand that there's been some good input. But manufacturers currently already have statutory and case authority to challenge proposed transactions if they view it as there are certain anti-competitive effects. Number two, as I said earlier in my testimony, there are a host of tools in the toolbox that manufacturers have to essentially stop the sale. And I want to be clear that we're not confusing. Right of first refusal does not take away a manufacturer's right to say you don't meet certain standards that we set forth. It's very clear under 46.2, I've listed it before, but there's a bundle of sticks there that they can pull out to basically stop the sale, including as broad as lack of good character, lack of financial ability, lack of reasonable motor vehicle dealership management experience and qualifications. So there is a lot of tools in the toolkit there, and I'd like to point out that some states have got rid of right of first refusal entirely. North Carolina does not allow it, period. And there is a substantive, I think, legal question. There was some question of multiple dealerships. There are some courts that have looked at these type of transactions and say, when you have these type of multiple dealer transactions, essentially you can't have a right of first refusal. It's not even applicable in situations like this. So I think it provides much needed clarification. I think manufacturers have a lot of tools in the toolbox there. I think all the parties will continue to work and possibly amend the bill. But I think if it's a pleasure of this committee to pass the bill up to the full committee.
Thank you.
Thank you.
Motion.
I'd like to make a motion, speak to the motion.
Speak to the motion.
I'd like to make the motion report.
Okay. Have a motion to report.
Yeah,
Speak to the motion.
yeah, speak to I think a lot of this comes down to size and scale in comparison. I think, we think about these auto dealers in our local community. You've got Page, in Northern Virginia, you've got, I think you got 600 employees, whether it's Petersburg, whatever it may be, and you're a big player in that community, you really are. But I think when you talk about the size and scale in comparison to the resources that I think some of these dealers have the ability to bring to the table, in conjunction with what you see in certain franchise law and the way that's dealt, I think in many ways you're dwarfed. You mentioned it with lawyers, with staff. So I think what this does, I appreciate Delegate Maris bringing it to the table, I think as it goes forward because of the court case, I think it really does just begin to level the playing field just a little bit, and give these people who are big players in our community, big employers in our community, provide a lot of jobs and resources. I think it just gives them a little bit of an additional edge, ability to breathe and to compete and to be successful. So I appreciate you bringing it forward, and I look forward to voting for the bill.
Have a motion to report. Have a second. With the substitute. reports 7-0. I will say this, I'm gonna ask the chairman if he will pass this bill by on Thursday. That would allow us to vote on the bill on Tuesday. I think there's some time constraints and some restrictions, but I will ask that you all please continue to negotiate to reach a conclusion that's satisfactory, okay? Now, I'm gonna ask the chairman, that doesn't mean the chairman will have to do that. So you all will have to check with the chairman to make sure that we do pass it by on Thursday, okay? Thank you, Scott. Committee rise.
Let me just have my